May I mention item number 13? Actually, 13, 13.
Yeah.
I am appearing for the appellant. But I have a part of matter in court number 13. As soon as it is completed, I will attend to a lordship.
Okay.
My junior will be here.
Okay.
Okay.
May I please, Lordship? Lordship, item number 23, my lord. Day before it, yesterday it was listed, my lord, the pay and recovery method, my lord, really consideration of release, my lord. Release of the 75% of the deposited amount.
Yes.
My lord may take up immediately after, my lord, the orders method, my lord. It will take hardly, my lord, 5 to 10 minutes, my lord.
Okay, we'll try. We'll try.
List, Lordship. Item number, my PS in regard to item number 59 of the part 2 list, Lordship. That's an appeal filed by the government. So, Lordship, my PS may kindly take up this matter on coming Tuesday, Lordship, on 8th of August. There's some urgency because interest is like accruing on the.
We'll try.
May I please? Well, I beg to mention 2 MEC appeals for order, my lord.
When do you want?
Any date, my lord. Yes, my lord.
You for the claimant?
No, my lord, responded. Quantum, my lord.
Huh?
The appeal is for quantum, my lord.
You're for the appellant?
No, my lord, for the respondent, my lord. The
Respondent what?
insurance company has victim, my lord.
That is it. We are for the claimants. You said no.
No, my lord, the appeal has been filed by the.
You're for the claimants.
Oh, my lord,
Not the appellant.
my lord,
There's a distinction between the
My lord.
claimants and the
My
appellant.
lord.
Yes, is there any stay order?
my lord.
Then,
First steps, my lord, steps are not complete.
no, if there is no stay order,
I need it.
no, what is the urgency? You have got 50%, haven't you?
No, my lord,
Why?
not given.
The appeal has been admitted subject to some payment, isn't it?
My lord, we have not got the.
You file an application for release of the payment.
May I please, your lordship? My lord, item 5, my lord, with consent, my lord. Any other date, my lord? First week of September, my lord. On behalf of my lord R. Gopal, he is, my lord, appearing in this case, my lord.
Item 5.
My lord.
My lord, there are multiple litigation between the parties, so it would be better if it is on September.
My lord, first week of September, my lord.
Goswami for whom?
My lord, petitioner, my lord, on behalf of R. Gopal, my lord, he is appearing, my lord.
Item number 5.
5, my lord.
R. Gopal.
My lord, he reflected in the order, my lord, from last 3-4 days, my lord, he is appearing, my lord. He is not well today.
You fix those. Huh? Oh, wait. 21. 21.
First week of September.
First week of September, any day.
On a joint request. This is a contempt matter.
My lord.
Yes,
Contempt of what?
of an order, my lord, of a IA, and which has arisen from a first appeal. And that first appeal has gone to probably to district judge court because of that pecuniary.
What is the allegation of violation?
My lord, I am for respondent. I would say it is a frivolous case. But
And what
in
is the allegation? What order?
allegation that
What order has been
that
violated?
tender has been issued without risk on risk and cost, but the tender has not been issued on risk. and
This
cost.
is a contempt matter. The contempt is pertaining to which order? Order directing what?
My lord, then let it be in item number 5. When it comes, then I,
Let the item reach.
yes.
Yes.
May it please, your lord. Lord, I beg to mention for listing of 2 RSs of 2004.
4.
Yes.
21.
Any date, my lord.
Next week.
Much of that.
Your lordship, I beg to mention one new item. Kindly the item may be listed for orders.
Orders. Case of which year?
It's 2023.
What is the stage?
It's a new case, I guess.
You filed recently, fresh matter.
Yeah,
When did you file?
on 26/5/2023.
So it must have come up once.
No,
It has not come up for consideration.
no,
What is the case? What is the nomenclature?
it's a
PRP,
RSA.
RSA,
Hmm.
come up for admission, not for orders. In the next week. Madam, is there any delay condonation?
Sorry, Your Lordship, I have no idea.
You should know the fact. Why are you saying for orders? There may be some IA for delay condonation. That is why. Have it in the next week.
Milord, here the government, Mr. Mojumdar appears, our Mojumdar, he just informed my associates that he is in port number 1, he will be coming and joining. He has asked me to start. Should I start with my? Is there? I will, yes. So may please your lord, huh? Sir, they have filed an affidavit, whether it has come on record or not. Lordship may kindly see.
By affidavit by
Affidavit by the state
responsible
Director of Elementary Education. It was
numbers.
Respondent number 1 and 2, for 1 and 2, they have filed it.
1 and 2, it has not come. One and two, it hasn't come.
It is not them alert.
What is the date of your,
It was
Filed?
filed on 24th of July.
no, it has not come. We have one affidavit of responsible 3 to 7,
Yes,
filed on 8/6/2020.
that is there. That is the private fund. And now the department has filed the affidavit.
We can have it tomorrow if if it is okay with you.
Or fine,
Tomorrow, immediately after the motions, Friday.
immediately after the motion.
So in the meantime, we'll have the affidavit.
Yes.
Part 3, take a Mohammed Senior Council for the petitioners. This court has been informed that an affidavit in opposition has been filed by the respondents 1 and 2 on 28/7,
24/7.
24/7/2023, which however is not with the record. List this matter tomorrow. Tomorrow date. Huh?
I'm appearing
Hello.
for respondent number 3 to 7.
Or later tomorrow. Put up, raise to tag the affidavit in opposition filed by the respondents 1 and 2, with the case record. We Tanukar for the department and Mr. Raskar for
3 to 7.
and
Respondent number.
Raskar for respondents 3 to 7. Take them on.
Obliged.
But tomorrow after the motion, we'll try.
Yes. Tomorrow after the motion.
It was very question devoted. Thanks for your work.
The second appeal, my lord. I am the plaintiff appellant, my lord. And today it is for admission, my lord. Admission,
It is for, it's under order 41 rule 11.
my lord.
we take it up for disposal.
my lord. If the
Substantial questions framed or not?
substantial question laws, no, already it is not been admitted, my lord. Only there is a delay condonation, my lord, petition. That's why, my lord, they are appearing and delay was condoned. And it is a substantial question of law, my lord. I am here to be framed, my lord.
Okay.
And my lord, or if your lordship taken up for disposal, then I have to.
No,
be-
no. Disposal will mean that we have to dismiss.
My lord,
Disposal at the admission stage cannot be allowing the appeal without framing substantial questions out.
my lord.
If we think that there are substantial questions, we'll admit. Yes, tell us what is the case.
That is the family tree, my lord. I have given, my lord.
Mm.
These are all plaintiffs are the, my lord. Plaintiff,
Sons and daughters of Yogeshwar.
Yogesh. And plaintiff, my lord, defendant number 1, 2, my main defendant are the sons and my lord, daughters of my lord, Siddheswar.
Yes, Siddheswar is your uncle.
Yes, my lord.
All sons of Sarveshwar, Yogeshwar, Siddheswar and
My lord.
Hemchandra.
My lord. So your lordship kindly see, and that performer defendant, my lord, they are Hemchandra. They are performer defendant. So your lordship kindly see my main substantial question of law, which I have came here, my lord. Your lordship kindly see, my lord, my suit was dismissed.
You are the plaintiff.
I am the plaintiff. My suit was dismissed.
Yes.
Our claim was that, my lord, this is our ancestral property. So we want, my lord, our share on title deed.
Suit for
Suit for, my lord, right title
declaration,
declaration
right title.
and confirmation of position.
Yes.
Suit was dismissed, my lord. And against that, my lord, I filed an appeal. In appeal, my lord, we have taken, my lord, about 16 count. But while appellate court decide the matter, only in one para, my lord. So that's why, my lord, substantial question of law, order 41, rule 31, my lord.
Judgment,
My lord,
format,
my lord. Order 41,
rule 31.
Rule 31, you have to give reasoning, not only that you have to formulate a point for determination. And even, my lord, there is a judgment, and if you conquer the, my lord, judgment of the trial court, then also you have to give an independent view. Simply we agreed with the so and so will not do. Because the first appellate court is the last court of law as well as fact, my lord. Both. So he has to, my lord, the lower appellate court has to, my lord, follow this 41, order 41, rule 31. But here in this case, your lordship kindly see the appellate judgment. Appellate judgment, my lord, your lordship will find, because we have formulated only two substantial question of law. Page 6, my lord, your lordship kindly see. Page 6, my lord.
Yes.
So here straightway goes to, my lord, page 8, my lord.
Is judgment dated?
Judgment dated 16/12/2017.
Title appeal 1.
My lord. Up to para 7, my lord, these are all facts. Para 6, my lord. That is the, your lordship kindly straightway goes to page 11, my lord, para 7.
7.
Para 7, the grounds set for this in this instant appeal are enumerated herein below the sake of convenience of the brevity. The suit judgment and dictate passed in the title suit number 4 of 2005 are bad in law as well as on fact. The same cannot be sustained but are liable to be set aside. That a court below misconstrued the provision of law applicable to the question involved in the suit and wrong appreciate the appreciation of finding thereby wrongly decided the suit to be the cause. That the court below failed to discuss and consider the pleadings of the parties as well as the evidence on record, decreed and suit against the appellant plaintiff with wrong appreciation of thereof, that the court below had wrongly decided the issues. These are the, my lord. Then para 8, the dispose of this instant appeal is decided in the Lana trial court. Also issue number 2, 4 and 5 appear to be crucial one. The certain the correctness of the decision arrived on these two issues. I have produced the entire record of title suit number so and so. The plaintiff, para 9, the plaintiff in order to establish their right, title and interest over the suit length relied upon the certified copy of the Jamabandi Exhibit 1, the suit patta. From a close perusal of the Exhibit 2, it is revealed that the name of all the predecessor interest, the plaintiff and defendant are there. It is seen from the records of examination of PW1 that this father expired in the year 1960. During their lifetime, his father purchased a land near the suit land and constructed the house therein, but could not complete the same due to his premature death. It is seen from the evidence of the defendant the entire suit land was given to the mother by their uncle through Benami transaction. The plaintiff appellant did not adduce rebuttal evidence in this regard. Further, the appellant plaintiff have no physical possession of the entire suit land, in which the court below is rightly held that the appellant plaintiff have no right title interest about the suit land which is executed by the aforesaid insurance. So that is the only parameter. In the instant suit, the appellant plaintiff have filed the suit for a decree declaring the right title interest about a suit measuring 1 bigha, 13 by the half lesser, dag number so and so, so and so, so and so. The appellant plaintiff have not paid for partition of the symbolic, not paid for partition or symbolic joint possession of the suit land, and the entire land in possession of the defendant number 1 to 4. The court below had rightly held that without partition of the suit land, decree cannot be granted in favor of the plaintiff appellant. So now, my lord, that's enough, my lord. Your lordship kindly see that appeal was allowed, appeal was dismissed. So only that para, my lord, para number 9. So even in the point of determination where there are also no discussion, my lord. So that's why, my lord, we formulated, my lord, order 41, rule 31 is one of the substantial question of law. Another point is that, my lord, order 7, rule 7. That is, my lord, not been complied with. That is also, my lord, your lordship kindly see the substantial question of law. Whether the learned first appellate court being a trial,
Where have you,
my lord,
where is it?
in very first page, my lord. Memo of appeal, my lord.
Ground.
Very first page. Now I have to, my lord, annex in very first page, my lord. There are 4 substantial question of law I formulated, but I will stick on 2 and 4, my lord.
Yes.
The whether the Nana first appellate court being the final court of fact refused to mold the relief in the plaintiff appellant as laid down under order 7, rule 7 of the Code of Civil Procedure. My lord, order 7, rule, your lordship kindly see order 7, rule 7. My lord, easily, my lord, this appellate court have passed the order for my lord partition, because it is without pair that can be granted, my lord. Now they says when there's a finding that there is no pair, that's why I'm not doing. So that's why, my lord, the or not complying the order 7, rule 7 will show one of the substantial question of law here. So in these 2 points, my lord, do this substantial question of law, your lordship kindly formulated and hearing that appeal on that point, my lord.
Let's see your plaint.
My lord,
Let's see your plaint.
plaint, my lord, page 40, my lord.
40.
start from page 40, my lord.
Yes,
So, my lord, that is why, my lord, even my lord, title they are not been able to, but exercising the power under section order 7, rule 7, my lord, they could have done it, my lord. It was not been done,
but there is no prayer for partition.
my lord.
The suit is neither.
No,
for
my lord,
partition-
since your lordship kindly see the finding of the lower appellate court, my lord.
No, see, the,
No, that is why what rule your lordship kindly see the order.
what-
7.
and this will change the entire nature and character of the suit.
No,
The
my lord,
suit was not for partition.
not for partition, but my lord, your lordship kindly see.
This molding of relief is within the four corners of the court. Now, when amendment itself, there are some strict restrictions. Even if you file an application for amendment, without an amendment application, can a suit for declaration relief can be granted for a suit? As
No,
it
that is your lordship kindly see. That is that I have annexed the, my lord, annexed the record of Jamabandi and all, my lord. Our names are there. That is last 5 years. That is there, my lord. So, my lord,
Actually, you may have a case, but unless the suit is for partition, you cannot invoke 7-7. First point is 41-31.
my lord, on that one also your lordship kindly admit it, my
41-31,
lord.
you may have a point. 7-7, we are not impressed.
Then, my lord, your lordship kindly see why I am submitting order 41 rule 31.
No, 41-31. Yes.
17th point, very interestingly, my lord, that was declared as adverse position. But question of course here adverse position, my lord, that one's also not discussed by the appellate court, my lord. So that's why on that point also your lordship
Yes,
kindly,
Doctor.
my lord, it's an admission, my lord.
My lord, the first thing your lordship.
Even
kindly
for
say-
admission, second appeal,
My lord,
there has to be substantial questions of law.
my lord, but on that, my lord, there is no provision for hearing understanding. Generally, for admission, my lord,
My lord,
It is under 41 rule 11. What is the purpose?
no, that is in the, that I'm just submitting last 32 years, my lord, I am seen then, my lord, in the admission, my lord, that admission, my lord, other side has no, my lord,
You're correct.
for admission, my lord, no, by, for hearing, my lord, it is there.
Let us see order rule 11. Please come to rule 11.
My
41, rule 11. Power to dismiss and appeal, dismiss appeal without sending notice to lower court. Please read. Order 41 rule 11.
Order 41, 11. 11, hey.
Every appeal shall be heard under order.
Every appeal shall be heard under rule 11 as expeditiously as possible and endeavor shall be made,
No.
concludes
Order 41 rule 11 you read.
order 41,
Rule 11,
11.
power to dismiss.
Power to dismiss.
Power without sending a notice to the lower appellate court. The appellate court left fixing a day for hearing the appellate to this pleading and hearing in the accordingly the appeal. And if appear to that, they may be dismissed the appeal.
Yes.
In on.
Yes.
My lord.
Yes.
Then, if on the day fixed for any other date which the hearing may be adjourned, the appellant does not appear, then the appeal will be called for hearing. The court may make an order to the appeal is dismissed. The dismissal of an appeal under this rule shall be notified in the court from which the appeal is notified. For when the appeal court not being the high court, dismiss on appeal under sub rule 4, it shall deliver a judgment according to before the so and so. So, my lord, why I am submitting, my lord, in admission, my lord, usually they have seen that, my lord, that is a court, my lord, matter.
Yes, anything you'd like to say?
My lord, very fundamental question in this case, whether the plaintiff would establish their right title and interest. Secondly, my lord, they are saying they are in possession. Now, would they
You had
establish?
entered appearance in the delay condemnation.
Yes.
Was there a delay
Yes,
condemnation?
my-
Okay.
Now, even they could not prove that they were in possession. We were continuously in possession.
No, you're going into the marriage. We are not exactly into the marriage. We are on the procedural part of 4131.
Now,
Where 4131 lays down a procedure.
Yes.
How the judgment is to be delivered.
Right.
Now, it appears that there is non-conformity. We'll frame this substantial question on 4131
no, my lord,
and
Your
we'll call for
lordship-
the record.
my lord, if your lordship look at
There is no
page
question of stay
25,
also, my lord.
if your lordship look at page 25, how the trial court adjudicated the matter.
Hmm.
My lord, the trial court has very specifically said they could not establish their title at
No,
all.
the trial court, the judgment of the trial court was put to challenge in the first appellate court, in which everything can be reconsidered, reappreciated. Here for us, it will be difficult, but first appellate court, the cards are all open. There is no restriction. But the manner in which the appellate court has dealt with this challenge, we don't think that it is in accordance with law. Let us see.
My lord, in that case, can I pray that instead of my lord keeping it here, today itself your lordship can send it back to the appellate court. Otherwise, as your lordship has observed,
Now see, under Rule 11, we can only dismiss. We are not dismissing this.
Yes.
We
Yeah.
frame a substantial question of law
And
and we fix it for early disposal.
my lord. There
it
is
is
no
early
question.
disposal, my lord, quite well.
TJ Mahasaran senior counsel for the appellant. How many appellants? Appellant, one appellant,
Only one. my lord.
appellant who has preferred this appeal against our judgment and decree, judgment dated 16/12/2017 and decree dated 20/12/2017. Passed in title appeal number 1 of 2014 by the learned district judge, Jorhat, whereby the appeal preferred by the present appellant against the judgment and decree dated 23/12/2013 passed by the learned civil judge Jorhat entitled to number 4 of 2005 has been dismissed and the judgment of the trial court has been affirmed. Admit. The present appeal is admitted on the following substantial question of law.
Want to follow? Main bit.
Sign number. That I hope.
डॉक्यूमेंट बोलेंगे लोडिंग मत
This court may, however, frame any other substantial question of law subsequently after giving opportunity to all concerned. Para. 3. As Datta is present for
1 to 4.
1 to 4 my lord.
corresponding numbers, as Datta senior counsel assisted by S. Musahari is present for respond number 1 to 4. Accordingly, Ms. Musahari accepts notice. Accordingly, extra copies of the memo of appeal may be served upon her. Para. Let steps be taken for the rest of the respondent numbers 5, EO2,
19
90 by usual process. Step within
week my lord.
a week.
My lord, as well as registered post.
But still is in difficult, my lord.
My lord, they are all pro forma. Otherwise also, my lord, they are not required.
Let us see user process. If it is required, later on we can.
My lord. Must.
If they are family members, you can intimate them.
The record may be called.
Following any other follow records may be called, let the records be called for.
Obliged.
May it please your lordship.
Yes.
Lord, in pursuant to earlier orders, Lord, we have already submitted my learned senior friend, Lord, the certified copies of all documents. He has verified that.
I have verified, my lord. I found it. Okay.
Lord, fix it. Can it be on 10th, 2010 matter? Accident is of 2004, my lord. So can it be on 10th?
We'll have it early. When?
On 10th, if possible, Lord.
10. 10.
Just 1 minute. All right.
Her PE learned counsel for the appellant. Para also had free as Dr. Learned senior counsel representing the insurance company who has submitted that pursuant to the last order dated 27/7/2023, the documents have been verified. Considering that the appeal is pending since the year 2010, registered to release this case for hearing on 10th of
August. I am deputy of
Obliged.
May I please your lordship. Lordship, in this case, I was asked to take steps by justice service. What I have taken an office note dated 1/8/23 shows that I have also filed affidavit, my lord, to that effect. None has appeared till now.
Where is the acknowledgement? You had made a statement that it was received.
My lord,
if you come to your affidavit, dated 27th of July,
July, my lord.
in paragraph 3,
See, my lord.
please read.
Man, in terms of the order dated by this December 4, that it steps upon respondent number 1A once he was released and served on point two, and duly acknowledged notice dated so to have been returned by the respondent number 1A 1C by acknowledging the receipt, which was received by the wife of respondent number 1C, my lord,
Yes.
who happens to be a doctor.
Now, where is the signature?
This is the signature, my lord.
Where?
Annexure 1 at the bottom, my lord. Annexure 1 at the bottom, my lord. Annexure 2 at the bottom, my lord. She happens to be a doctor, my lord, and the wife of notice number 1C, 1A, my lord. Hemen Barali.
What is the name of the wife?
Kalpana Barali, my lord.
Who has served?
My lord, I had said my clerk, my lord.
He has not given any affidavit.
No, my lord.
Clerk should have given an affidavit. You have verified this paragraph has true to report.
No, my
This is
lord.
the personal service. The person
My lord, my
who affects the service.
my learned junior property to my clerk, my lord. Clerk had tendered, my
So
lord.
where is her affidavit?
That affidavit has not been filed.
See, Dusty is all on assumption. So that's why we insist on the affidavit. Here, Mukutmani has given the affidavit.
My lord.
He has said that this part of the government is
Because
true as part.
she had accompanied with the clerk, my lord.
He could have given, clerk could have given.
And she was present, my lord, at the time of this service. That's why the one man is given.
Where is her affidavit?
Mukutmani Bora.
No, Mukutmani was there. At the time.
She was dear, my
So
lord.
where has she written? Then why record? Why paragraph 3 as per record?
Because my lord, this justice service has been annexed with this.
Justice service is not because of the signature appearing in the record. He knows that it has been served.
Sir, my lord.
It is in
And
front of him.
in proof of service, my lord, this has been annexed with this affidavit.
This
That's
is
why
not a
that's-
matter of
that has
record. Mr. Alam, you know what a record. Because only because the document is there, it becomes a record. That's not the thing.
no,
Communication made by you, it's not a matter of record. Your
My lord-
result sheet may be a matter of record. Some documents with the authorities is a matter of record. But here, the fact of serving personnel is something which is personal to you. It was done in your presence.
But my verification to the effect of that this party is of record.
And
Because-
and Muktimani has not said that he was there.
No, this has not been stated, my lord.
See, I'm the appellant taking steps to ensure direction. He has not said that I have gone, served. Steps upon has been taken, released. It's all.
My lord, in support of the statement made in paragraph 4, my lord, your lordship cannot see. This was handed over to the advocate's clerk. I am going to file an affidavit through this clerk, my lord.
And it was on the same date of
The clerk who tendered, my lord, I am going to file an affidavit.
has duly complied. He has not said he has accompanied. He has said he has complied with the
So
order.
that part is missing. That's why, my lord, I'm going to supplement by the
Give me an affidavit. by the clerk.
affidavit by the clerk, my lord, who tender the same, my lord.
Yes, yes, that will be enough. I would say an alarm, then a counsel for the appellant. Appellant who submit that the remaining respondent numbers,
1A and
1,
1C.
1A and 1 have been served justice, in support of which an affidavit has been filed on 27/7/2023. Put the para- A perusal of the said affidavit tag, kept with the record as flag that would, however, reflect that the notices were tendered by the advocate clerk who, however, is not the deponent of the affidavit. Put the para. Sri Alam, the learned counsel at this stage, pressed for some time to get an affidavit executed by the advocate clerk in support of such. Put the para. Time is granted. Para. List of 2 weeks,
1 week sufficient, my lord. 1 week.
list after 10 days.
Did make a fix it, my lord.
Tell us. List, don't say 10 days, list on
14th, my lord, if possible.
today is,
3rd, my lord.
yes, 14.
Much.
What is the
My
content
lord,
about?
before the allegation which is that I have violated Annexure Y, page 154 to 158. Before that, my lord, I just give you a gist, my lord, I am a PSU under Ministry of Heavy Industry. I am being given work by Ministry of Home Affairs for construction of border outpost. And as per my terms and conditions, I can further allot the work to a third-party contractor. And
No, who are you?
I'm the respondent, my lord.
Respondent cannot be a PSU. It's an
Yes, the
individual.
officers are these people who are being implemented as contemners.
Yes.
They are the officials of a PSU.
Okay, tell us that.
Yes.
Respondents are officers of EPIL.
Yes, Engineering Projects India Limited.
Then,
My lord, Engineering Projects India Limited is being given work on nomination basis for constructions of 13 numbers of border outposts.
yes,
Now, my lord, after as per the terms and conditions of the contract between Ministry of Home Affairs and Engineering Projects India Limited, I can further allot my work by tendering basis to some other contractors. And that way, I have allotted it to J Brothers. J Brothers is my lord, applicant here of this contempt petition. So even after 35 months of expiry of the contract, they were not able to give delivery of the border outpost. So
it was a tenure board,
tenure of 18 months.
18 months.
But after 18 months, even after 35 months, they were not able to give delivery. We have given them repeated notices.
Yes.
And ultimately, my lord, we had to terminate the contract.
Okay.
Upon termination of the contract, they have filed a suit against Engineering Projects India Limited. J Brothers have filed a suit
Okay.
against Engineering Projects India Limited before Civil Judge 1, Kamrup Metro Guwahati.
Okay.
And the work is of Mizoram, but exclusive jurisdiction is at Delhi. So we have filed that it is beyond jurisdiction. And there was a mispetition also for injunction, wherein the learned civil judge Kamrup Metro has given a injunction order that fresh tender cannot be given. We cannot go for retendering of the work. So we have filed a FAO before Honorable Guwahati High Court
Against the injunction order.
against the injunction order, along with the IA 1346 of 2020.
For
For we are to be given that we are to be allowed for retendering of the work.
okay.
And in that IA, my lord, the order has been passed on 30th of September 2020. As per the petitioner, we have violated that order. And that order is in, my lord, it is in Annexure Y, page 154 of the petition,
154.
154.
Okay.
My lord, at the very first, I come to the parties, my lord, in page 154. In that case, my lord, Engineering Projects India Limited and three others are Group General Manager, and Project Engineer. And Engineering Projects India Limited, having its own identity, that is as per ABC of corporate law, it need not be represented by the CMD. But the Group General Manager and the Project Engineer has signed that petition, FAO and the IA. Now, my lord, in this order, if we come to 157, last two paragraphs, my lord, may I read these two paragraphs?
Yes, please.
I have given due consideration to the submission made by the learned counsel without entering into the merits of the findings of the court below on perusal of contract documents annexed in this petition. My lord, this is very important. I am satisfied that the completion of construction of border outpost is of vital importance to the security of the country. The issue involved in the suit filed by respondent can very well be decided after evidence is laid by both the parties. Moreover, if at all the plaintiff respondent succeeds in the suit, he could very well be compensated in terms of money. On the other hand, if the order under challenge in the connected AP is allowed to remain in force, irreparable loss would be caused to the petitioner appellant, and as such, I am inclined to stay the operation of impugn order dated so and so 20th/12/2019, passed in Mizze case number so and so, arising out of title suit 527/2018, which means a title suit and Mizze case is pending till date, my lord. Pending in the court of learned civil judge number 1, Kamrup Metro at Guwahati, and the petitioners shall go ahead with fresh tender process without applying risk and cost liability on the respondent contractor till the disposal of the connected appeal, and the same shall be considered at the time of disposal of the appeal. So that FAO is also there. Because of pecuniary jurisdiction, it has gone back to district judge now. My lord, the last paragraph. The necessary formalities before handing over the site to prospective fresh contractors shall be maintained by petitioner as per terms and condition of the contract entered into by the petitioner and the respondent contractor. So, my lord, I am being in the top paragraph, I am being allowed that with the condition that I should not apply risk and cost liability on the respondent contractor.
Yes.
My lord, the first thing is that my lord, since he was doing a lot of arbitration and civil practice, my lord, risk and cost is a process to be recovered from the contractor. It cannot be imposed on the other contractor, third party contractor, or third party contract cannot be given that I would recover money from him and give it to him. So
Now, what is the violation alleged now?
my lord,
What is the violation alleged?
violation is that I have issued a liquidated damage letter, which is the last phase of this. Last phase of this petition. They are considering that liquidated damage is risk and cost. My lord, these are two separate things, even in Indian Contract Act.
Page
Last page, my lord,
174.
174. This is my letter.
LD has been imposed.
Yes, I have imposed LD on them. And in that letter, I have stated that above imposition of liquidated damage, last paragraph, my lord.
Yes.
Last paragraph, my lord have got it. The above imposition of liquidated damage is without prejudice to the right of EPA to claim further amounts on account of risk and cost, which is subject to outcome of appeal pending before the Honorable Guwahati High Court.
Yes.
So these are two different separate things, but they are alleging their pleadings is in, my lord, regarding liquidated damage, it is in paragraph 37 and 38 of the petition.
738. Yes.
Para 37, my lord. Page 17.
Page
Page 17.
17.
Yes, my lord.
Yes.
May I read, my lord?
Yes.
That on 5/10/2020, Assistant General Manager Engineering Projects Limited at Guwahati imposed liquidated damage of rupees 5+ crores. Being 10% of the value of work, this is absolutely beyond contractual obligation. The employer contractor has not been authorized to impose liquidated damage in the event of termination of contract. Why not? I don't have any answer, my lord. That part is inconsistent with the order passed by Honorable Court on 39/2020, whereby the contract awarding authority was allowed to go ahead
Separate
with the
application is
tender
filed to
without
establish-
imposing risk and
Last line. Separate application is filed to assess.
still this action of imposing liquidated damage. Yes, my lord, there is a separate application, and in that separate application, it has been stated, and that order we have annexed it in our affidavit
Paid by the first appellate court.
by the High Court.
No, you said that it has gone back.
My lord, this is a separate writ petition.
Read petition.
Yes, my lord, and that we have annexed it, my lord. It is there in page 29 of my affidavit, my lord.
In WPC.
In WPC, my lord, 391 of 2021.
Okay.
This I have annexed it in my page 28 of my affidavit, annexer 1.
Okay.
My first affidavit, my lord. My lord, I have also filed an affidavit.
This is the only averment regarding the contempt.
No, another averment is
Or
there.
where is the other?
My lord, before going to the other averment, my lord, another affidavit I have filed on 22/11/2022. In paragraph 5, I have stated that I have regarding issue of, this is, my lord, generally it is something which is beyond business sense or whatever it is. My lord, therein I have said that there is no respondent hearing stated that tenders were issued without applying risk and cost. So it cannot be issued without by applying risk and cost because it is a third party tender. Risk and cost has to be recovered from
Yes, no, what is the second allegation?
second, my lord. If we come to my lord, that original order which has been
Now, where is the averment? Tell us. In this contract petition?
my lord, it is in para 34, page 16, that I have not done joint measurement. Para 29, my lord. Para 34, my lord.
Yes.
My lord, it is hearing it, they have stated that it is may I read, my lord, 34.
Yes, yes.
That it is relevant to point out here that the general condition of contract in clause 72.4.1 subclause E is very much clear that before handing over the work performed by the contractor has to be measured. Till date, no data of quantum of work performed by applicant plaintiff was sent to the applicant plaintiff. If the work is not measured, the applicant plaintiff would be deprived of his due amount for his performance of work.
Hmm.
This is against the order passed by Honorable Court on 39/2020.
Let us against the 39 to 20.
My lord, there is no specific, that is what it is reported in one order also, my lord, of this court in this petition itself.
Yes.
My lord, the last paragraph, it reads in 157.
Yes.
The necessary formalities before handing over the site to prospective fresh contractor shall be maintained by the petitioner as per terms and conditions of the contract
Right.
entered into by petitioner and the respondent contractor. So my lord, like to show to my lord one order.
Let us see your tender.
Tender is there. my
No,
lord.
no, your, what have you written? Have you regarding risk and cost? The first tender, not with him.
Fresh tender I have already given to him. And I have already produced at the court.
No. After this contract was terminated,
Yes,
you had gone for a fresh tender process.
yes, my lord.
Who have you gone ahead with the process?
Of joint measurement.
No, of the fresh tender.
Yes, my lord. And now the almost we have
No. Let us see the that tender. What is your clause on risk and cost?
risk and cost of those tenders, my lord. Those are there, my lord.
Have you expected anywhere?
My lord, I have given that I have not this in my affidavit filed on 22/11/2022 in paragraph 5.
Is what have you stated?
The respondent herein states that tenders were issued without applying any risk and cost liability on the petitioner. And as such, there is no contempt of order dated of the
The
honorable.
risk and cost is the normal parlance which you use against the fresh contractor, isn't it? And
Yes,
in case of termination, it will be done at your risk and
my lord.
cost.
My
It's got
lord,
nothing to do with his rights and liabilities.
no, nothing, my lord. My lord,
Yes. What?
My lord, actually, my lord, I am not engaged counsel in this case on behalf of my lord R. Gopal, my lord. He's from Delhi, my lord. I problem is going on, my lord, in Delhi. That is why, my lord, I have been instructed
Got to
to.
hear a petitioner. This is a matter between us and the contender.
my lord. One more order, my lord. It is in passed by this honorable court in this petition 17/2022.
What order?
Yes, my lord.
17?
2022.
Yes.
My lord.
Yes. Yes.
My lord, second paragraph, starting with in order.
Yes.
In order to consider the submission advanced by the petitioner counsel, I have perused the order dated 39/2020, passed by the court in IA Civil 1346/2020 and find that there is no direction from the court in the manner in which the petitioner counsel is canvassing in this case. According to Mr. Kaushal, the respondents have handed over the site to the new contractor without carrying out measurement of the work done by his client, and the petitioner has also been asked to deposit a sum of rupees 5 crore as
Yes, I have read this. Rightly observed.
yes, my lord.
We
Why
close
not?
this, we close this. This is an abuse.
Yes, my lord.
Not any other date, my lord, kindly, my lord.
We are closing this. Contempt, you have got nothing to say.
Yes, my lord.
Your name?
My lord, S.A. Sikdar, my lord. Kindly, my lord, after 1 week, my lord, kindly, my lord.
As I seek the Leonard Council,
On behalf of my lord, R. Gopal, my lord.
Leonard Council has submitted, has prayed for an adjournment on behalf of his senior. Full stop.
R. Gopal, my lord, kindly, my lord.
Senior Sri R. Gopal. Full stop. Para. A matter alleging contempt being essentially between one, which is being essentially one between the court and the alleged contemptor, comma, the prayer for adjournment is rejected. Para. The order which has been alleged to be violated is dated 30/9/2020, passed by this court in IA
1346.
in IA 1346/2020, arising out of FAO number
27 of 2020.
27 of 2020. Full stop. Para. A contract which was handed over. No, don't write. Para. The present respondents are the officers of Engineer India Private Limited.
Project in engineering project
Engineering Project India Limited.
India Private Limited.
Engineering
India
Project
Limited.
Packet India. Right open. It appears that the Ministry of Home Affairs from a Government of India had entrusted the work of construction of 13 numbers of border outposts
Border.
in the state of Assam,
Mizoram.
in the northeast,
In the state of Mizoram.
in the state of Mizoram, bordering
India Bangladesh border.
bordering Bangladesh. The EPIL was also authorized to get the works done by way of by floating tender process. Para. Pursuant to the same comma, one of the work for border outpost was allotted to the present petitioner. Full stop. There were disputes with regard to the work in question, wherein the principal contention of the company, of the respondent, is that though the work was to be completed within a period of 18 months, comma, even after 35 months, comma, the work was not completed. And accordingly, comma, the contract was terminated. Full stop. Para. The state termination was the subject matter of a suit instituted before Civil Judge number 1, Kamrup at Guwahati. Full stop. Para. Sri Goswami, Learned Counsel for the respondent submits that the court at Guwahati was not having any jurisdiction, was not having any territorial jurisdiction as the work pertained to Mizoram, and the jurisdiction was conferred to the competent court at Delhi. He, however, submits that despite such facts and circumstances, and in an order of injunction was passed directing that no fresh tender process be issued. Full stop. It is the state order dated 30/11/2018, which was the subject matter of challenge in the FAO number. What is the FAO number?
27 of 2020.
In the connected FAO. Full stop. Along with the state appeal, IA 1346/2020 was filed to allow the respondents to go for retendering as the work in question was of immense public importance and delay was against the interest of the country as a whole. Full stop. This court, by the order dated 30/9/2020, had passed. I had disposed of the state IA by passing the following directions based on E2A. Para. Para na. It is this order dated 30/9/2020, which has been alleged to have been violated. A perusal of the petition would reveal that the allegation of violation is made mainly in paragraph 34 and 37, which are expected herein below. 34, 37, page 16, page 7. Para. 3. Goswami, the learned counsel for the respondents, have drawn the attention of this court to the order dated 17/2/2022, wherein this court had come to a prima facie satisfaction that the present petition alleging contempt was not maintainable. However, on the request of the parties, the matter was adjourned. A perusal and an examination of the allegation pertaining to the allegation of contempt as stated in paragraph 34 and 37 does not bring this court to even a prima facie satisfaction that there has been any violation of the order dated 39/2020. Full stop. The averment made in paragraph 34 is with regard to certain functions to be conducted before handing over the work performed by the petitioner. Full stop. In paragraph 37, the petitioner has stated regarding imposition of liquidated damage. Full stop. This court is of the considered opinion that neither of the said allegation, even on its face value, can be deemed to be in violation of the order dated 39/2020. Full stop. Whereas Sri Goswami, the learned counsel, has also informed this court that the matter regarding imposition of liquidated damage has been separately challenged by the petitioner by filing a writ petition being WPC 391 of 2021, and therefore the said matter would be is the subject of adjudication in a different proceeding. Full stop. Sri Goswami has also submitted that allotting the contract to a third party after the permission was granted by the court, in which a risk and cost clause was included, is the third party, and has got nothing to do with any such risk and cost with relation to the present petition. Full stop. He has also drawn the attention of this court to the communication dated 5/10/2020, correct? 174? Page 174?
Yes, my lord.
5/10/2020.
Yes.
Whereby it has been clearly stated that the matter of risk and cost would be considered after matter of risk and cost is the subject matter of the outcome of the appeal. Full stop. This court has also been informed that due to change in territorial jurisdiction, the appeal has now been remanded to the learned district judge, Kamru. Considering the aforesaid facts, circumstances, a petition for contempt has to, a petitioner alleging contempt has to make out a case of willful and deliberate violation of a court order. Full stop. In the instant case, comma, there does not appear to be any violation of the order at all. And the present attempt of filing a contempt appears to be lacking bona fide. Full stop. The petition is accordingly dismissed.
Ablash, ma'am.
Your Lordship will file an additional affidavit in this case, Your Lordship. Can you permission me to give it?
You have filed a additional affidavit.
No, we will file affidavit
Additional affidavit regarding what?
regarding condemnation petition, Your Lordship.
Why additional affidavit?
Uh,
You have not filed your affidavit.
We will give further averments regarding the delay, Your Lordship. Because,
How much was the delay? 772 days.
yes, Your Lordship.
We had taken up this matter earlier, I think.
Yes, Your Lordship. On the last day period.
We are not satisfied with the delay, I think. With the explanation. Madam,
Lordship, kindly a date may be fixed in this matter.
how much time?
2 weeks, Your Lordship.
Jedas,
Yes, Your Lordship.
Jedas Planet Council for the applicant. Praise for and is granted 2 weeks time for filing additional affidavit in this IA. Full stop, para. Your name?
D Devi.
Rasri D. Devi, Ms. D. Devi, Planet Council is present for respondables 1 and 2. Full stop, para. List after 2 weeks to enable filing of additional affidavit.
Okay.
In this case, service is complete, Lordship. LCR also come. Matter is for hearing.
Admitted.
Already admitted.
Lordship, but Lordship, 50% has not been completed.
This is workman compensation.
Lordship.
What is the state, what is the deposit you are required to make now? You're the insurance company.
Yes.
Or after the large judgment, you are not required to make payment.
Lordship.
Aren't you required to make any payment deposit?
Here is no direction for the payment, Lordship.
No, as per law, what does the law say?
Matter may be finally heard, Lordship.
So how much was the amount?
Lordship.
Awarded amount is
13 lakhs.
13,63,280.
That case,
Yes.
pay some amount. How will the widow survive? Who's the claimant now?
Lordship, father.
Father.
Is it?
He was a bachelor.
Yes, sir.
This was a bachelor.
Yes.
In the next week, Lordship, maybe finally disposed of, Lordship. The small point is involved in this case, Lordship.
2020 matter. There are matters of 2005, 6. To tell us why we should not pass an order of directing you to deposit 50%, at least
Maybe consider, Lordship.
we pass an order. Heard. Three. This is item number
7.
7. K.K. Bhatta, Learned Council for the, this is United India,
Lordship.
for the insurance, for the appellant insurance company. Whereas the IHOC
Yes, Lordship.
Learned Council is present for the respondent number one.
Yes.
Full stop. While Sri Bhatta, the learned council, has submitted that the appeal being admitted
Already admitted.
on appeal being admitted on 10/5/2023 and record have been received pursuant to the same order, the appeal may be listed for hearing as the respondents have also entered appearance in the meantime. On the other hand, Sri Hawk, the learned counsel for the respondent number two, submits that till now, no amount, whatsoever has been paid or received by the claimant. Considering the above and the objective of the statute, the appellate insurance company is directed to deposit 50% of the award for the registry of this court within a period of 2 months from today, which puts upon the claimant would be at liberty to get the amount released on being properly identified by the learned counsel and upon furnishing a bond.
Highly average.
Lordship, in this case, I need 3 weeks time because next week I won't be here to file an objection to their ILR. For withdrawal.
Or withdrawal of the amount deposited by the insurance company, Lordship. Withdrawal of the amount deposited by the insurance company, Lordship.
I
There
number
are two-
1989
two grounds.
How
One
much
is
is the amount deposited?
30 lakhs.
30 lakhs.
60 was the
Yes.
more than 60.
Yes,
Who had passed
40,
away?
no, the amount,
50%.
43 lakhs,
Amount is 43 lakhs.
30,000.
interest.
Lordship, 50% with interest deposited.
Okay. Let him get it released.
No, Lordship, we have to file because Lordship, in this case, Lordship, first line of the judgment itself, Lordship will read that they were gratuitous passenger. They paragraph 2, Lordship. Case of the claimant in brief is that on 29/7/16, the deceased was proceeding towards her residence from Silchar as a gratuitous passenger in the Maruti car, Lordship. Lordship, so let's file the objection, then Lordship can pass it
Lordship,
because the insurance company has a right to present their objection. And otherwise also we have annexed the policy with the our memo of appeal, Lordship, wherein premium was paid for 5 passengers for PA cover to those 5 passengers, and the cover was 1 lakh of rupees. So if 1 lakh they want to release without objection, with the bond, Lordship, we can. Yeah. But
No.
for the
How did the learned tribunal arrive at this?
learned tribunal arrived as per Balakrishnan, but it has
Balakrishnan.
not gone to Asharani's case. Gratuitous passengers, they cannot claim equally applicable to them, Lordship.
Lordship,
So Lordship, let's file the
No,
objection
no,
now.
no. How did the learned tribunal
Lordship,
Lordship, 16
arrive at the quantum?
paragraph 6, quantum, Lordship, she was working. Income was taken as, that is at 16, page 16 quantum calculation.
Yes. She was working as what?
Yes, she was working.
Working as
assistant teacher of HSC school.
getting
Come on.
51,000.
Lordship. Lordship, so far as occupant is concerned, Lordship, in view of the decision of the Balakrishnan's case, occupant is covered in case of a package policy. Gratuitous passenger in a car is occupant. If paying passenger is there, that is another aspect. But gratuitous passenger is occupant. The occupant is covered in case of package policy. Lordship can see. Balakrishnan case, Lordship.
Lordship, that
paragraph-
way even I needed opportunity, Lordship. I came for an adjournment today that I'll file the objection. I can give the certificate, judgments, Lordship, for graduate fashion.
No, no, where is the, is there any IA file by you?
Yes, his IA is Lordship, 1989 of 23.
Lordship can see paragraph 21, Lordship.
Okay, I have come for the first, okay, we'll grant time. But we'll grant time only because the procedure prescribed. Otherwise, we're inclined to release them.
Fine, Lordship, but we can at least put it on record, Lordship,
yes,
that we objected to that. Lordship.
Yes, that will grant you the time.
Yes.
3
weeks, Lordship, next week, because I won't be here, Lordship.
Lordship can
Item number
19, Lordship, supply list, Lordship.
M. Talukdar.
Lordship. Lordship can see the paragraph
Your name is
21.
not there in the policy, why? Part P. M. Talukdar, learned counsel for the applicant who by means of this application has paid for a direction to allow withdrawal of 50%.
50% with interest. That is
50%
amount
of
has
the
been
amount
mentioned,
with
30
interest.
lakhs, 78,000.
With interest, which was deposited by the applicant pursuant to the order date 31/3/2023 passed by this court in IE Civil 853/2023 arising out of MSC appeal number 112 of 2020. Para MS R.D. Mazumdar, current counsel for the opposite party appellant, however, praised for time to file objection. Para, praised for 2 weeks time.
3 weeks, Lordship. Because next week I won't be here.
Okay, well, 2 weeks, I mean, fix the date after 3 weeks, 2 weeks time to file affidavit of opposition, to file objection. So, Para, please, on, give a date of your convenience when you will be there.
July, August, no, Aditini. Lordship on 29th, Lordship, August.
29th August. Order? As agreed to by the parties, this on 29th of August.
Highly obliged, Lordship.
May I please, your Lordship? Lordship, as per last order, my lord, it is, my lord, day before yesterday, my lord. This date is fixed
Madam, where
for
is
consideration of,
Yes,
this date is fixed for consideration of, my lord, the withdrawal application, my lord. Because, my lord, while admitting the appeal preferred by them, like the tribunal directed to pay and recover, my lord. The appellant has prepared the appeal by saying that, my lord, they have, by saying that the license, my lord, license was not valid.
Oh.
That's why, my lord, tribunal directed pay and recover. And now, my lord, my lord, when the appeal was admitted, 75% was directed to be deposited. They have deposited, my lord. And when I filed an application for withdrawal, my lord, the appellant has filed their objection. And but till date, my lord, that has not been considered. And
okay, madam,
Order was passed, Lordship, that his IA will be taken up as final hearing. I'm ready for doing the hearing, Lordship, because the
where is that order?
Lordship 25/3/22. The IA will be heard finally, list on
25?
3/22. But final hearing also, I'm ready, Lordship. Today also it is fixed for
Three.
final hearing. So
25, 3, 22,
22.
where? There is no such reflection in the IA.
I don't know, Lordship. In my, yeah, I have written the I will be heard finally. It was,
What is
There
your
was
eye,
no such
Mr.
direction, my
Rathore?
lord.
Lordship.
What, Mr. Rathore, where is your, which is your eye?
My lord,
His-
I is my
Oh,
lord.
really? Number?
Yes, yes. I is 322, my lord. 322, 2022. As per my information, my lord, I have filed this IA for withdrawal on 31st January 2022. And
But
my
there's an
lord,
order. Unfortunately, application shall be considered along with the main appeal.
I have that. is one.
We would have passed the order.
my lord, the last occasion, my lord.
No, there's an order.
You
in
did
this
not
eye.
inform the court this thing.
My
No?
lord may take up for final
There's
disposal.
final disposal.
Yes, my lord.
Number one. No? It is for hearing only. Let's go for hearing.
Yes, yes, my lord.
Let's come back and we'll start the hearing.